Welcome. It's already time to start, and we have a quorum. So first of all, let's invite the team from the administration to join us. Good morning, ladies and gentlemen, and Happy New Year to you all. Ms. Xie, I think you are still working on the questions that we asked last time. So for today, you intend to carry on with the cross-by-cross scrutiny, right? For the questions already asked in the past, you would like to take them up at one go next time, correct? Yes. Last time, we stopped at section 20. For section 19, I think the LA has still got a question. This section 19 in clause 9. So over to you, LA. Not really a question. Just want to share with you my observation. In subclause 3, 5, and 7, it has been assumed that the stop order is such that the court may vary it, suspend it, or revive it. So this is on the assumption that the court has such powers. But right in the beginning, I've already raised the point that is we have to be sure that the court enjoys such powers. So first of all, we have to make sure that the power has been given to the court to vary, suspend, or discharge the relevant orders. I understand that the administration is taking up this issue with the judiciary about the powers of the court. I think this is quite important, so I hope you will clarify with the judiciary. Last time, there were also a few points that we have asked you to take up with the judiciary. Indeed, Mr. Chairman, we have already started our liaison with them. For the administrative guidelines, I think you have promised to give us a gist of the guidelines, right? Yes. For those of concern to you, they will be summarized for your reference. We're still working on them. We intend to come back as early as possible. All right? So please turn to section 20 of clause 9. The new one, and this is to implement proposal 4 of the LRC. This is to detain a child if the child is being taken away out of Hong Kong against the order. So we hope that we can provide an opportunity to allow our law enforcement agencies to have time to come into contact with the parent who has the right of custody. Section 21. For the authorized officer, it means a police officer or an immigration officer. And then when the immigration officer in doing the clearance finds that someone intends to violate the stop order, or if one of the parents have already applied to the court in relation to a prohibition order, and someone would like to take the child out of Hong Kong, then the relevant officers may detain the child. And then under 24, if an immigration officer detains a child, then the officer will liaise with the police ASAP so as to turn the child to the police for custody. For 26, the police, as soon as practicable, will take the child and keep the child in a place of safety until the custody parent can be contacted, and then the child will be returned to the relevant person. And then under 26B, if after a reasonable period of time has elapsed and the police cannot contact the relevant person, then the Director of Social Welfare will take the child to a place of safety, like the homes under the Protection of Child and Juvenile Ordinance. Mr. Tam Yuk Chong, if I may ask this question. If the applicant's relevant application has been turned down by the court, then can the administration clarify this point? I want to know if the applicant can reapply again. Say, for example, even before being turned down by the court, can he submit a second application, so that it will result in a scenario such that the child will be forever subject to the relevant procedures until he comes of age? Mr. Chairman, if an application has been refused, the question is whether there can be further applications. Before the application has been rejected, since the application hasn't been handled, the application is still alive, so you're not supposed to have a second application. I think it is a procedural question. Maybe the DOJ can give an answer to this question. This is my understanding. Before an application has been dealt with, it is impossible to put in a second application regarding the same matter.
And Mr. Tam's question is, if the application is ended or the application has been turned down by the court, can the parent apply again? Well, I think this has to do with the procedures. Is the DOJ, do you have anything to say on this? So if the facts remain unchanged and based on the same facts and the application has been turned down, well, it doesn't say categorically that he can't apply again, but it is expected that the application will be turned down very soon again. To my understanding, well, please, I stand to be corrected. If an applicant has made an application once and has been turned down, and if there are no changing circumstances, the applicant makes the application again, it is really abusing the judicial system, and the court has a right not to process the application unless the applicant can prove that on this particular case there is a material change in the circumstances, highlighting the need to apply again. Then under that case, a court can handle or process it. Is my understanding correct? Yes, that's correct. So it depends on whether the applicant is deliberately abusing the judicial process. Legal advisor, anything from you? Let me supplement. According to clause 15, that has to do with the prohibition order, and that has to do with the proceedings and also the rights of custody of the child. And Mr. Tam is worried whether the case will be dragged on indefinitely, because when we talk about the right of custody proceedings that may come to an end 1 day. Now, if the application comes to an end, well, either party may make the application again, but then that only can happen when there are new circumstances. That's my understanding. All right? Well, please continue. New clause 21, and that is to implement the other observations made by the LRC, and that has to do with the stay of custody application pending determination of proceedings under the convention, the Hague Convention. This is to implement the Hague Convention Article 16, and that is if a child becomes subject under the Hague Convention application, and before that proceedings ends, the courts should not make any ruling on the rights of custody of the child. Legal advisor, do you have a question relating to Section 20? Yes, I have put that down in writing previously. Section 20, subbracket 2. In clause 17, then the recovery order. Now, if the recovery order is being invoked, and then the child has been returned to the parent. Now, if the parent wants to take the child out of Hong Kong, would the child be detained under subsection 2 of Section 20? If the child is returned to the specified person under the recovery order, the specified person can take the child out of Hong Kong. So my follow-up is this. Now, according to the way it is drafted here, the wordings here mean that the child can still be detained because the recovery order will also be notified with the immigration director. Now, in subsection 2, the recovery order has not been discharged. And if these conditions are met, the immigration officer can still detain the child. Sorry, speaker not coming through. Sorry, speaker not coming through. Under the recovery order, the parent has handed over the child to the specified person. Now, if the specified person takes the child away, the DOJ or the applicant will then withdraw the recovery order from the court. And if the recovery order is withdrawn, so the Section 20 will automatically become invalid. Well, that's the normal procedure. Oh, all right. Section 21. Any comments? If not, then we'll please continue. Part 2 of Clause 10, that's a minor amendment. That's cross-reference to Schedule 1 because we added in Section 21. So originally it said Section 3, so we will try to substitute it with Sections 3 and 21. Part 3 now, and clauses 11 and 12, that has to do with the amendments to rules of the High Court, Cap 4, subsidiary legislation A. Section 12 makes an amendment to the Order 121 as a consequential amendment because of the Section 2(9) of the ordinance, we have added in Section 21, and i.e. there is a stay of proceedings, custody application, pending determination of proceedings under the convention. So we have to make the amendment here. And we also add in clauses 12 and 13. And i.e. that has to do with an application for an order under Section 13. And that has to do with the other jurisdictions outside the habitual residence of the child, and that has to do with Section 18. So we propose to add in clause 13, searching for, inspecting, and obtaining copies of documents filed in proceedings under the ordinance, and that is in Order 121. And that is to implement the LRC's recommendations on confidentiality related to the convention, and that is to prohibit the members of the public from accessing the files related to the proceedings under the convention. Thank you, Chairman. I hope that you can reflect this to the judiciary. In reality, the registrar or the clerk of the court often forget to keep confidential such affidavits and related documents. And very often, many people, because of the negligence on the part of the High Court registrar, can access these documents. So please remind the judiciary that the documents should be sealed and kept confidential. Please make such reminders that people not related to the cases will not have access to the such documents. Please do that. Any questions from members? Well, if not, then please continue. Ms. Share. Part 4. Clauses 13 to 16. Amendments to Matrimonial Causes Ordinance and its subsidiary legislation, Cap 179. Clause 14. We plan to add in Section 848D. So that is an order for prohibiting removal of child out of Hong Kong. This new 48D will repeal or substitute Section 94(2), and that is to implement the LRC's recommendation to include this order for prohibiting removal of child of Hong Kong into the primary ordinance and not in the subsidiary legislation. All right. Well, let's look at 94. It says that if there is no objection, then leave from the court can be applied. Is that right? Yes, correct. Part 5, clauses 17 and 18, and that is has to do with amendments to Judicial Proceedings, Regulation of Reports Ordinance, Cap 287. So that is to prohibit the publication of information relating to proceedings of the Hague Convention, and that is to also to implement the ARC's recommendation on confidentiality. So that's also related to the previous amendment. I want to ask 1A. On an anonymous basis, can you elaborate on this point? Perhaps the DOJ, Mr. Lai? Thank you, Chairman. This is in accordance with the recommendations of the LLC's recommendation. For rulings under proceedings under the Hague Convention, the ruling normally does not contain the name of the child. Normally, the name of the child would be sort of blacked out. Well, in that case, well, the wordings here seem to be unclear. So you meant that the identity of the child will be deleted. But then you said that the publication of a judgment on an anonymous basis may mean something different than just blackening out the identity of the child. Normally, when we review the rulings, the name of the child will be blackened out, and a sort of another code will be there to represent him or her. Now, in 1A, what you meant is really deleting the information related to a child. Can you just put that down per se like that, instead of using the wordings on an anonymous basis? Well, there is something good about the way it is written here, because it will be allowing the court more flexibility in writing out its ruling. And the court has an effective way of writing up its ruling. I don't think there is a need really to redraft this point. But anyway, we'll go back and reconsider what you suggested.
Paul, I think you're absolutely right. In fact, I find it a serious problem, the way it is being drafted, because it is most confusing. And then an anonymous basis, I think this is used to qualify the publication. I don't think the drafting can reflect the meaning. Now, the anonymous basis doesn't really qualify the names of the parties rather than the publication. So instead of not knowing the identity of the child, it seems that we won't know who publishes the judgment. So to me, the current drafting is not proper. Do you understand his point? Yes. So please go back to consider whether it should be changed. Part 5. Please continue. And that's it. Legal advisor, anything to add? No, not for the time being, Mr. Chairman. What about other members? It seems that you haven't got anything to add for the time being. So what's outstanding is that we have to wait for the administration's reply to the questions asked this time and last time. So we're waiting for your response, and we would like to get a summary of the administrative guidelines. For the date of next meeting, when are we going to have our next meeting? The 25th of February, tentatively speaking. Do you think you have sufficient time to do the work? We need to match the timetable with the Secretariat. In March, quite a lot of members are out of town, including myself, so we may not be able to deal with it. So if you need time to prepare the response, do tell us. Anything else on the AOB? No? Then meeting adjourned. Thank you. Thank you, Mr. Chairman.
Okay, done.